Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. Glad you could join me today. In this particular episode, I'd like to talk a bit about some problems that can occur with one of two types of petitions. Either the K1 fiancé petition, and actually it would also involve the K3 spouse petition, and also just the normal marriage petition and everything involved with that. So there's different kinds of issues that arise when we enter into these types of petitions. And essentially, what you have to do is know about these types of petitions and what it is that will occur if these issues exist, and if it is necessary, in which to either do a waiver, whether a waiver is needed, or whether you can't get a waiver, and so forth. So I'll just start with the fiancé petition. There's and when I'm talking about these issues, it's fairly common with whether again it's the fiancé or the K3, but it comes in more often with the fiancé petition. So first, let's talk about the issues that can arise with this particular petition. Now, I've done lots of different videos before on the fiancé petition and what is necessary, especially in regards to the Walsh waiver. Okay, so I'm not going to do a whole other video on the Walsh waiver, other than to let you know that it, of course, does involve basically sex crimes against a minor. You know, and it can be a whole different variety of type of crimes against a minor, such as kidnapping, false imprisonment, solicitation, solicitation to practice prostitution, video voyeurism, possession, production, distribution of child pornography, criminal sexual conduct. It goes on. It's fairly broad, but basically any type of crime in regards to the specified offense against a minor from the petitioner will require the Walsh waiver to be filed. And go ahead and look on my video for the Walsh waiver to see what's involved with that and the difficulty and how you can overcome it. So that's one, of course, area of impediment. But what about other issues that might arise that would cause problems, or that would necessitate you having to look twice in order to get the particular waiver? Well, or the particular issue. Well, one is if the petitioner has previously filed a petition within 2 years. Okay. Now, sometimes people come to me and their clients, they'll say, well, I filed this petition for fiancé and it didn't work out, or I filed that petition for fiancé and it didn't work out. Is there any problem with filing another one? And the answer is yes. There is an issue. They want to make sure that basically you don't have this person who's petitioning person after person after person in a manner that is not consistent with what would ultimately be a bona fide marriage. So what you have to do is first look and see how many petitions the person has filed in order to determine whether or not this is of an issue. Okay, and by petitions filed, I'm basically talking to regarding fiancé petitions. So you have to look and see, first of all, where the petitioner, that would be the U.S. citizen, previously filed petitions for 2 or more fiancés, and the previously approved petition was filed within 2 years. Now, if this is the case, then uh, another one cannot be filed unless there is a waiver of the time or numerical bars. And there's another one as well, in that basically if a subsequent petition is filed less than 10 years after the date the first petition was filed, then DHS has to basically notify the beneficiary about any of these subsequent approved petitions, and it won't go forward unless you do a waiver. Now, the waivers in this particular respect are, if you're comparing them to the Walsh waiver, is way easier. Okay, I'm not saying it's easy. Nothing is easy in immigration, but it is a whole lot easier than doing a Walsh waiver. So you have to essentially do a waiver of the time or numerical bars. And factors they consider are unusual circumstances such as death or incapacity of a previous beneficiary. Look at petitioner's history of domestic violence. Look at the pattern of filing multiple petitions for different beneficiaries at the same time, or filing and withdrawing petitions. So even if you file it and later withdraw it, it's going to come up in this particular context. Look and see if there's approvals every few years and so forth. So, basically it looks at these different factors. One thing, of course, that will be a problem is if the petitioner, again, the U.S. citizen, has a record of violent criminal offenses, then it won't be granted unless you can show in extraordinary circumstances that it should be. And again, there's all kinds of ways of showing that through psychological reports, evidence of rehabilitation, other compelling factors. There's always ways of putting together a good waiver. But it's a lot more than saying my spouse needs me, please let me in type thing, or my fiance is going to miss me if this is not approved. So it's quite a lot of work, but if you really want it to go forward, then you have it done correctly. Now, so we have the issues of previously filed K-1 petitions. We have the issue of sex crimes against a minor, which necessitates the Walsh waiver. And then there are past criminal convictions from the petitioner, which don't fall into the Walsh waiver categories, but may necessitate having a waiver as well. And these are different kinds of criminal history that are specified basically where it involves domestic violence, it involves all kinds of basically issues where is violence and bodily injury. Okay, obviously, if there's some conviction that has nothing to do with injury or violence, it's not going to be an issue in regards to the fiancé petition. I mean, it may be an issue between the later spouses at some later point in the future, but in regards to the actual crime itself, what you need to look for is, again, taking any specified offenses away from a minor and looking at any kind of criminal history that deals with bodily injury, violence. There's also ones that deal with multiple violations of drugs. So there are a few of them. You just to list a few: domestic violence, sexual assault, abuse and neglect, dating violence, elder abuse, stalking. These are ones that just jump out. There's other obviously obvious ones: homicide, murder, manslaughter, rape, abusive sexual conduct, incest, torture, trafficking, peonage, holding hostage, involuntary servitude, slave trade, kidnapping, abduction, okay, unlawful criminal restraint, false imprisonment, or attempt to commit any of these, or 3 convictions for crimes relating to a controlled substance or alcohol not arising from a single act. So you can see that it's not just carte blanche to be able to file the fiancé petition. Some people think, well, they don't have a sexual crime against a minor, so therefore they don't have to worry about anything, and that's not exactly true, as you can see. And so what do you have to do if you have one of those crimes? Again, you can show extraordinary circumstances as to why it should be granted and so forth. Obviously, you're going to want, you being the petitioner, will want to disclose this to the beneficiary, because if you don't, immigration will. So, you might get an approved waiver and think you're home free, only to find out that, you didn't tell your beneficiary, and sure enough, your beneficiary, she will find out through immigration, and everything will, might be over. So there certainly has to be some disclosure. So this is basically a very brief overview of issues that can arise when doing a fiancé petition. The other obvious issues are you haven't met in person within the last 2 years. So, if you've been Skyping, 14,000 times a day for the last 5 years but never actually met, that's not going to work unless, and again, you can file a waiver for that. You can show there's some extreme circumstances why you can't. Just mere financial hardship will not do. I have had people who will tell me, well, I can't get off of work. Well, immigration doesn't care about that you can't get off of work, okay? You're going to need to meet the person unless it's, going to cause some very serious discomfort, basically, if you have medical issues, or if there is some cultural or religious reasons why you can't physically meet the person prior to marriage, or the fiancé petition being approved. And then, of course, there's the issue of whether there needs to be a bona fide marriage. Of course, the bona fide marriage means that the engagement is for purposes of love, and not for purposes to ultimately get the green card. Like when the person gets the green card the day after he or she says goodbye. So you want to make sure that there's sufficient proof in regards to that. And then, of course, there's all the other grounds of normal grounds of inadmissibility that exist with any type of non-immigrant or immigrant visa. I've done lots of videos on those types, but I did concentrate on a couple of the more specific ones as to the K1. So if you like the video, go ahead and click like, subscribe. I usually put out a video about once a week, and then you can go ahead and email me. I do give free consultations for the initial one, let you know what can be done, what the costs are, and so forth, and then we go from there. Okay, more on the coming videos.